Hi, I'm Dean Serwin. I am the chair of the Beverly Hills Bar's Law Practice Management and Wellness section. We're presenting this panel today, or this program. It's not really a panel. And I've got a little bit of housekeeping. As you can see in the chat, there's some notices going up. This is part of the Beverly Hills Bar's on-demand program. So this program will, within 24 hours or so, the recording will be available on the BHB app on demand. It's a fantastic program. If you haven't been utilizing it, please do. It makes your MCLE compliance literally a snap. It took me about 2 minutes last time because I'd done enough of these programs. They're all right there in a locker. You do a couple of clicks and you're done. It has all the harder to get programs, and there are new, interesting, exciting programs as opposed to things that are 10, 20 years old, like some of the, get everything for $75 systems. So I encourage you to check it out, tell your friends about it. And if there's something in here that you wanted to, refresh, you can go back and watch it yourself. Anyway, now on to a little bit more housekeeping. As you see in the chat, there are some materials. Those are available in the chat. They'll get reposted a few times. This is a webinar. So instead of being able to directly communicate with Annie, she will be presenting. There is a Q&A button, though, down at the bottom. So you can, at least I believe there was before. I'm not seeing it right now, but so you can post any questions. You can't chat directly with her, but at the end, there will be a Q&A section, and someone from Beverly Hills Bar will be monitoring that to answer anything that the bar can answer for you, like, hey, where are the materials, kinds of things. So anyway, let's introduce you to Ann L. Thompson. She's the Chief Claims Officer for Lawyers Mutual Insurance Company, who is a co-sponsor with us of the BHBA On Demand program. They've provided professional liability insurance to California lawyers since 1978. She oversees the claims department, managing litigation strategy, legal analysis, and coverage evaluations. Ms. Thompson also assists policyholders with ethical concerns and participates in mediation and settlement negotiations. We're very excited to have her here presenting this program, Ethical Calendaring, Protecting Clients, Cases, and most importantly, your practice. So with that, I'm going to go off camera and say, take it away, Annie.
Well, thank you, Dean, for that introduction. Yes, I'm Annie Thompson, and I'm the Chief Claims Officer of Lawyers Mutual, and also a certified legal malpractice specialist in the state of California, of which there are approximately 100 of us, and that's about it. So I am also, along with my very talented team at Lawyers Mutual, I answer a hotline, which is where our members can call in about best practices for how to handle things like disengagements, conflicts, things like that, as well as, an interesting topic that does come up, which is calendaring. It's overlooked. It doesn't feel particularly exciting, but hopefully we will get through this seminar with you learning some good practical tips about calendaring. If you've ever seen me speak, this program is going to be a little bit different. I'd like it to be a little more conversational. I welcome the Q&A, and I'm going to talk about various topics, but what I'm going to do is I'm going to veer off into my sort of best practices / hotline practical advice based upon things that I have seen in 25 years of defending lawyers. I originally was a litigator defending lawyers in legal malpractice actions for 10 years before I went in-house 15 years ago as a claims attorney with Lawyers Mutual. And now, like Dean said, I oversee the department. So again, if you have any questions, feel free to interrupt in the presentation, as someone else may have that same question, or I will save time at the end. So thank you for joining me. In the next hour, we're going to explore a critical but overlooked aspect of legal practice, which is calendaring. Specifically, we're going to delve into the importance of calendaring for California lawyers, the ethical obligations associated with it, the potential consequences of failing to implement an effective calendaring system, and the tools available to you to ensure compliance and efficiency. And I'm going to start with a little bit of a history lesson as to sort of how we got here and where we're going. So California became a state in the 1850s. By 1872, we already had the California Code of Civil Procedure. It was not formalized in the way that it is now. So we based our California system after English common law, and everything was primarily handled manual calendaring with clerks maintaining handwritten dockets and ledgers, and the court proceedings and deadlines were in the physical logbooks. And thereafter, in the 1900s, the growth of the court system, the volume of legal cases increased, necessitated organized calendaring systems. And organization is going to be kind of a, a thoroughfare in this presentation. So then we had these paper-based systems, including printed calendars, and they became standard for scheduling hearings, trials, and deadlines. What the courts did is they used term calendars where cases were set for certain terms, and that led to greater consistency. Consistency, again, is going to be a thoroughfare of this presentation because it is going to be, it's critical to your practice. And then in the 50s and 60s, the CCP finally gave us a system of structured rules for deadlines, filings, hearings. There were statutory rules that formalized response deadlines for pleadings, motions, and appeals, and the law firms were still relying on paper for that. But I'm guessing that's when legal malpractice actions probably started as well, because the formalization of the CCP and the rules led to a more uniform guide for lawyers to follow and deadlines that were meaningful, practical, and consequential. And then in the 80s, when we got our computers, the first digital calendaring systems came. And this is, I'm talking about calendaring today, but ultimately I'm going to end up talking about digital calendaring. A lot of people I know are still in paper calendars and, maybe have a another paper backup. But I'm going to encourage you today that best practice is going to have electronic calendaring, and I'm going to share with you why. So law firms started using the early case management systems in the late 90s, and that introduced digital docketing systems. And then in the 2000s, we got e-filing, and then the case management systems became widely used. I highly recommend them. I don't have a particular provider that I would track you to, but a lot of law firms are using Clio, MyCase, Practice Panther, and that implements electronic case access as well as calendaring completion and collaboration with your case management software. The case management software really can make your practice uniform in the sense that you can track your trial date. You can input your trial date, and it will populate, and your venue, and it will populate all the deadlines, with a formula that is a lot less room for human error. Footnote to that on the best practices is you have to vet your vendors. You have to make sure they're updating regularly with the legislation. Like, I don't know if Clio, MyCase, and Practice Panther have implemented the new rules on the timing for motions for summary judgment in California. That obligation lies with you. So there's going to be a lot about sort of non-delegable duties on calendaring that I'm going to talk about. The interesting thing also is that this talk may become irrelevant in 10 years because AI is already generating calendaring tools to assist attorneys with deadline calculations and compliance, integrating with court rules databases to ensure automatic updates when laws change. And there's also a push for statewide uniform electronic calendaring aiming to streamline scheduling across counties. So we are not there yet, but I think we will be very soon. So now that we've completed our history lesson, the landscape in California now is that we have heavy, heavy caseloads of increasing complexity. And the court has adopted e-filing and other digital processes to make these things a lot easier and have a lot less room for error. If you have not yet implemented an electronic calendaring system and you are using paper calendars, there are a lot of benefits, and sometimes people need to be motivated by benefits in a win-win situation. And there's really three things that I have selected as the reasons why. I'll list them and then I'll go through, the reasons, and then I'll give you some real life reasons why this matters or should matter to you. Efficiency and productivity is a benefit of electronic calendaring, accuracy and reliability, and client service. Those are the three main topics that I've identified as the benefits of electronic calendaring. Now, going through them individually, efficiency and productivity, automatic reminders for critical deadlines, court dates, and client meetings. I'm going to talk about client meetings in a second and how calendaring those, and the integration with other tools like your document management system, which is going to lead me off course a little bit to you need to look at CRPC 1.6 about keeping client data secure. Your calendaring system and your CMS systems need to be secure. It implicates Rule 1.6 of the Rules of Professional Conduct. You as a fiduciary have an obligation to safeguard all of your clients' information. So when it comes to those case management document systems, there's some homework to do, which we will get to, and I have a checklist for you as well on that. Another benefit is accuracy and reliability. The human error in penciling in and erasing in your, black, day planner that many of us had, if you're, you're over the age of 40. We had the black, day planners that we wrote everything in, and there's a lot of room for human error. This reduces human error in tracking statutes of limitation and court deadlines, and it synchronizes across, has the ability to synchronize across devices to ensure access anywhere, anytime. My calendar is here, my calendar is here, my calendar is in the computer, it's in the cloud. I have 3 different calendar systems. I have Outlook Calendar, I have Google Calendar, I have an app called One Calendar. They are all integrated. If any one of them fails, I still have access to all my information in the cloud. And I'm not a litigator. And I will tell you that I think the reason I was asked by Beverly Hills Bar to do this program is because this is what my calendar looks like. This is how I stay efficient. It is color coded. It is filled in with all sorts of information. And while it may give some people anxiety, it allows for a lot of accountability. So talking about accuracy and reliability on statutes of limitations and court deadlines, I'm going to veer off into do not wait until the last day to calendar your statute of limitations. This is sort of my practical advice, my hotline advice here, is I have seen so many claims come in because someone strategically or because of the way they calendar filed too late because they calendared 1 day late or on the last day, and one of the parade of horribles happened and it didn't get filed. There is absolutely no strategic reason that I can think of that outweighs the risk that you've calculated incorrectly. Add that cushion. We have seen that far too many times where it's 1 day late, 1 day early. There's reliance on documents that, have confusion. Always calculate the earliest possible date and then add time to that. I've seen lawyers that have had cases come in, a 2-year personal injury statute of limitations. They get right after the accident, they get the case, and then they wait 2 years to file. Sometimes I understand they're still treating, you want things like that. file anyway. If you need to toll afterwards for continued treatment, if you need to stay the case, do that. But do not wait until the last day to file. Calendar a month before, 6 months before, whatever it is. And as far as calendaring goes, also, that also means make sure your calendaring and your CMS system, if it's a personal injury case, accounts for, if you have other pre-filing obligations like a government tort claim or something like that. So that's the reducing human error in tracking deadlines, is you can input that and your electronic based system will greatly guide you in doing that. But my practical tip is not to wait till the last day, even if your electronic system tells you this is the day, because I'll go through some war stories in a bit to show you exactly how this can backfire. And then the last benefit of electronic calendaring system that I mentioned is client service. Um, Timely updates and proactive communication with your clients and enhanced transparency in managing deadlines. I believe no matter what your practice area is, you should be calendaring regular client updates. Does not matter if you are contingency, hourly, or doing defense work. This, how you handle a client and how you communicate with a client honestly dictates how your relationship will go, how it will end. It avoids conflicts in the middle of the case because, the duty of communication of, Rule 1.4, you have a duty to communicate all relevant details to your client. As lawyers, as busy lawyers, there's a lot of dormant time sometimes, and clients don't necessarily realize that if you've gotten their case resolved in 3 years, you're basically a hero. But clients still need to be communicated with. Most of them are lay people, depending on your practice. Calendar 30-day updates. Dear so and so, the past 30 days I've been in a discovery battle. I don't have any documents yet, but I will provide you an update as to the impact and meaning of the documents as they apply to damages as soon as I get them. Clients want communication. And so, in addition to calendaring deadlines, you should be calendaring client meetings. If you're contingent, you have a nervous client who doesn't really know the legal system, and you have a duty to educate them of the material things going on. If you are hourly in a plaintiff's case or a defense case and you're billing clients, they're entitled to know what the outcome or consequence of what you've been doing. If you're sending a bill, you also need to be sending a letter indicating what that work revealed, how it impacts the case, whether it was beneficial or detrimental to the case. And I'll talk a little bit about later about, if you do make a mistake or a calendaring error, all this communication can lead to, a healthier resolution that avoids malpractice claims. A quick example on the statute of limitations and not waiting until the last day. We had a claim that just came in where the client put the wrong date of injury on the intake form. The lawyer relied on it. The lawyer had documents, hadn't gone through the documents because they calendared the statute of limitations date based on client intake information. All the documents had a different date that was earlier. And it's going to be, can be hard to defend a case where you've had the documents and haven't looked at them because you've calendared a date the day before it's due to be filed. So there are a lot of risks in that. So I've taken up a lot of time on that, but I think that it's critically important that, and also if you are regularly calendaring updates to your client, even pre-lit, then you're going to continue to be reminded as to what the statute of limitations is if you're continually communicating with your client, which can be onerous depending on your caseload, but can, be highly beneficial down the road if you are ever sued for legal malpractice. So we'll talk about that as well. So calendaring is not just about managing appointments. It's about safeguarding the rights and interests of your clients, maintaining professional integrity, and ensuring compliance with legal deadlines. The practice of law is very deadline driven, whether it's filing a motion, responding to discovery, or appearing at a hearing. Missing a single deadline can have big consequences for your client and your practice. So missing a deadline, dismissal of a case, sanctions, other adverse rulings, they harm your client. So the real life consequence of that is a lot of times, it's a delay, but a delay doesn't make the client happy and can result in you getting substituted out. Sanctions against you or your client can create a conflict and obviously a financial burden. Adverse rulings for which you have not notified the client of the possible risks of also can put you at risk for malpractice and ethical violations. So the reality of that is, you miss a deadline. The client still has a lot of hoops to jump through. And I do want to share that with you, that missing a deadline isn't the end of the world. I'm going to walk you through how to disclose that later on. But what the practical thing that happens, and I'll use, an auto accident as the easiest example, is, if you fail to file on time, that doesn't mean necessarily that anybody has a great malpractice case. It all depends on what the value was of the underlying case. So the client still has to jump through the hoops of proving not only duty, breach, causation, and damage against you, but the case within the case, which means they have to litigate the underlying case, and they can have $1 million worth of injuries. But if the underlying defendant was uncollectible, but for a $15,000 auto policy, those are the damages. So, but we're fiduciaries. We don't want our clients to have to jump through those hoops. We're not here to screw them in any way, and we're not here to do our jobs improperly. We are here to make those deadlines, argue these cases, and get them to conclusion with a good client relationship. So one of the things that I'm going to talk about, because this is an ethics presentation, is what the rules of professional conduct that mandate competence and diligence, how they apply and why they should be important to you. And the other thing I'm going to talk quite a bit about is your professional reputation. Consistently meeting deadlines fosters trust among clients, colleagues, and enhances your professional reputation. A lawyer that repeatedly misses deadlines is going to miss out on referrals. A lawyer that is not communicating with their clients is going to miss out on client referrals. Communication and calendaring that communication in an electronic format so that you have time specifically set aside, meeting with so-and-so, call with so-and-so. Clients want to be touched. They want to know exactly what's happening. If you have one of those clients that says only contact me when something, when you need me to make a decision, fine. Most clients are not like that. And if you ignore the client because nothing's going on, that leads to a lot of distrust. And I see that a lot. And the lawyer's defense is, there was nothing going on. I was in a discovery war. I have no documents. And, the court hasn't set us for a hearing for 6 months out. Well, the client still wants to hear that. And you should be calendaring all of those things. And your professional reputation, if you're consistently missing deadlines with, the bench and the bar, is not something that you want to be known for. So going through, the key ethical rules for lawyers, and the most important one is Rule 1.1, which is competence, requiring the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. The key here is, as of March 22nd, 2021, the California Supreme Court altered Rule 1.1 of the CRPC and changed not the text, but added language in comment 1. And it says the duties set forth in this rule include the duty to keep abreast of the changes in the law and its practice, including the benefits and risks associated with relevant technology. Which is why I'm here saying your old paper calendars may have been good enough before, but I don't think they're good enough now. And you don't have to necessarily invest in the most I mean, if you're a solo practitioner, you can do things through Outlook and Google Calendar. You don't have to necessarily make a big investment, but I will share with you that the investment pays off. The other rules that apply equally are diligence. Failing to act with reasonable diligence in representing a client is a violation of the California rules of professional conduct. Again, this is an ethical issue. Failing to act with competence includes, with diligence and competence go hand in hand. Being a diligent lawyer means being a communicative lawyer. Being a communicative lawyer means carving out the time to communicate with your client with regularity so that they are sufficiently informed, which then brings us to Rule 1.4, communication, ensuring clients are informed about significant developments. And this is really the rule that I think actually should inspire lawyers to use their calendaring systems to their benefit. It makes you a better lawyer if you are continually making sure that your clients are satisfied with your representation. A client will not be upset if nothing is going on, but a client will be upset if nothing's going on and they've left 3 phone calls and messages that you have ignored. Which again, I'm laying the groundwork for a landscape in which you may have to disclose a calendaring or other error. So again, this bedside manner in communication and utilizing calendaring for communication, again, will make you a better lawyer with a better reputation and more referrals and more client satisfaction. I talked a little bit about Rule 1.6. Again, this is an ethics presentation, so I'm going to present you with all the ethical rules that apply to this. When you collaborate your case management system and your calendar system, I also recommend that you have another system as well for just your calendaring, because your CMS system is great and it's probably going to give you the most accurate information, but you also need to make sure that you have something else that if anything happens to that CMS and it goes down, that you have not lost your calendar and your schedule of when things either need to be filed, whether you have meetings coming up, court appearances, case management conference, mediation, mandatory settlement conference, all those things, you still need to know when they're going to occur. So backups to backups to backups are really the key on this, and it seems onerous, and your black daily planner may have served you well for a long time, but when that gets stolen from the front seat of your car, you're in trouble. So when you integrate, also make sure, and I have a checklist at the end, and we're going to talk about how to evaluate features and vet vendors a bit, but you do have the ultimate task of making sure that your client's confidential information is safeguarded. And then the last rule, which I think is as important as, the competence rule and the new addition to it, is Rule 5.3. Again, this is an ethics presentation, and I'm going to go through all the rules that could conceivably apply to calendaring. And this is responsibilities regarding non-lawyer assistants. And this is a big deal, because a lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer, and the lawyer is responsible for the conduct of that person. If you delegate your calendaring, you need to have double confirmation systems in place. I saw a case where a lawyer communicated to his assistant, these are the, please calendar these dates. Well, the assistant writes back and says, one of these dates is a Saturday. I think you have it wrong. And the attorney never responds, and the date never gets calendared. Nobody follows up. So there needs to be protocols. Again, that's the lifeline through all of this, is protocols and consistency, and everyone's buy-in on technology. Everybody knows how to do it, what their job is. But if you are emailing your assistant to calendar a date, it's your job to double check that that date is in there and is accurate. I mean, again, that's where the human error component comes in, and everything lays at your doorstep. So you cannot say, and we've seen this happen before, we've seen assistants who've basically just sort of given up, who have old school ticklers that they just haven't given the lawyer to file. That's why that doesn't work anymore. So you really need a lot of redundancy in this department. But again, it makes you a better lawyer with a better reputation. And if you have calendar entries for each client, even pre-litigation, you minimize this risk. If you are in communication with your clients regularly, pursuant to Rule 1.4, you are going to minimize the risk of missing deadlines because you're going to be in communication with your clients regularly. Okay, so what are the risks of non-compliance? Missed deadlines lead to malpractice claims. We've talked about that. Yes, your client has hurdles, and the legal malpractice law in California is very defense friendly. Again, we don't want to put our clients through that. Generally, we want to do the best work we can as fiduciaries. And as fiduciaries, you are subject to disciplinary action, and the state bar, I can tell you, is not super interested in, I missed the statute of limitations. They'll say this is for the civil courts. If you repeatedly and recklessly miss deadlines, even on a single case, if you miss an opposition date, if you miss a court date, if you miss all these things, it's a great example of a case that maybe there's time to get a new lawyer, and maybe it's all fixable, and maybe it had no legal consequence to the underlying case. The state bar will care about that, and you could end up on the receiving end of disciplinary charges. So that goes both ways. There are certain things that will lead to your breach of duty to the client, can lead to damages, but not a state bar complaint. And then there are situations where there will be no damages that could be ascertainable by the client, but because of repeated and reckless conduct, the state bar will care about your duties of competence and loyalty and diligence with this particular client. So these are not small risks. These are big risks. Hopefully everybody has insurance. If you don't, call Lawyers Mutual, shameless plug. But those are the risks. And there's also data security risks if you are using outdated or unsecured calendaring methods. You have to make sure, just because you implement something once, that you're not, it is fluid, and you need to continue to monitor these systems that you utilize to make sure that they are secure. I mean, we have at our company an add-on to the policy for cyber breaches, and they happen. I just had one the other day where a criminal lawyer literally saw before her eyes all of her Dropbox documents disappearing. So you need to make sure, like, what happens in the event of that? How are you, my vendor who I'm paying, how are you securing my confidential client information? And again, tech compliance, now that that's a real rule, it's really hard to say that your calendaring system in your black notebook is sufficient. So let me go through some real world examples when you fail the calendar. I have six here. I may have gone over some of them, but again, a missed filing deadline. California attorney representing a client in a personal injury case forgot to file a lawsuit before the statute of limitations expired. Claim forever barred, leading to a malpractice suit. I would say in that situation, my sort of side note on this is call your carrier. As soon as you figure out or realize that you've missed a deadline, call your carrier. They may have some guidance for you on whether or not there is a fix, whether there's a remedy, whether there's a way to continue to represent the client, whether you can file and allege some sort of, whether it's tolling provisions, how old the client was, whether if it's a government tort claim, if you can file a late one. If you have a carrier that has that kind of hotline and assistance, call your carrier and they'll walk you through that. I will walk you through what to do in that situation. And I'll talk about it in a bit about, how you make that disclosure to a client, because that's a really important ethical issue as well. Court sanctions, if you don't have effective calendaring systems, you can, fail to appear in a mandatory case management conference or mandatory settlement conference because a date isn't calendared. You can get sanctions against you and your client. Your client has suffered unnecessary delays, which they're allowed to complain about. They may not ultimately affect the outcome of your case, but it does cause client distrust when they see you being sloppy. Effective electronic calendaring keeps you clean. You don't want to be messy about any of this with your clients. And again, administrative errors, which goes back to the rule about 5.3 about delegating to your assistant. You've got paper notes to track deadlines. Your assistant inadvertently misplaces a file. The attorney missed a deadline, resulting again, tarnished reputation, sanctions. And reputational injury, although, it's one of those things that people talk about. Getting sued, I don't think is reputational injury. It happens to everyone. It's a cost of doing business, and it happens. But reputational injury, if you are in a certain practice area and you have a reputation for being messy, for missing deadlines, for constantly asking for extensions, for serving objections only to delay, your referral system will dry up from your lawyers in your bar, from your clients who may refer you to a friend. It will lead to, distrust in the bar, and, the bench officer who sees this, who you may be appearing in front of regularly, you don't want that reputational harm. Again, good calendaring systems avoid this. Again, another example, and I may sort of go to the worst example, but the old school example was, you've got 45 minutes before deadline, you sent the courier to the courthouse, the courier got stuck in traffic, now you're a minute late, and again, this goes to don't wait till the last minute, and if you do, make sure that you have sufficient guarantees in place that it can get filed on the correct day. Because if that was a valuable claim, your client has lost. I talked about the case that may not have been so valuable with the $15,000 limits. There are cases that are valuable, and if you've got $1 million case that you didn't file timely, then you've got $1 million claim on your hands, and underwriting history and things that you just don't want to deal with. You want the actual proper defendant to be paying that. You don't want to be paying that because of your own error due to miscalendaring. And these are all sort of like, it's asymmetric risk. It's associated with calendaring and docketing errors, meaning like a minor mistake can lead to a major problem. And here's where the most major problems come. And I call this the triple error cover-up. first you file in the wrong jurisdiction, and then the corrected suit isn't filed until after the statute is expired, and then you attempt to cover it up. So this is based on a real world example, and what the court in that case did is they issued a combined compensatory and punitive damage award of $35 million in the malpractice suit that followed. The cover up is worse than the crime. Always, always, always. Because then that can lead to fraud allegations. So I want to talk, and malpractice claims are going up. The profile of legal malpractice claims that the ABA put out in 2012 to 2015, and then again 2020 to 2023, basically aggregates data from malpractice insurance carriers, and it says the volume of malpractice claims and associated costs have grown and are continuing to grow. Going back to the cover up is worse than the crime and disclosing an error. This is really important, and it's not necessarily it doesn't give you the context of the calendaring vetting, but it gives you the context of what happens when you make that calendaring error. And if you were to call in on the hotline, the best practices that I always tell everyone is you cannot cover it up. You have a duty to disclose to your client what happened. And I believe that should be, a 2 to 3 part process. The first thing you do, presuming you have a good relationship with the client because you've been communicating, you call the client in for an in-person meeting, you offer to go to their house, you talk to them on the phone, you have a Zoom meeting, but you have something oral where you factually say what happened. All you're doing is saying what happened. You're saying, the deadline was X, I filed on Y, or I didn't file on X. This obviously impairs your ability to move forward with this case. You may have a claim against me. And there's 2 parts to this. If it's something you think you can correct, at the very least, you need a conflict disclosure or a waiver to continue to represent them to try to fix the error. I say this in every presentation, but you're never more aligned with your client than you are when you've made a mistake that you want to remedy. Nevertheless, it is required that you disclose the potential conflict, and a waiver would be best practices. Following up on that telephone call, which you are not saying, I'm so sorry, I made such a huge mistake, and you're factually disclosing, your carrier doesn't allow you to admit liability on anything in any policy. So you don't want coverage concerns. But then you tell the client, I am obligated to follow up under the ethical rules with a letter to you. And that letter to you, I want you to look at. If you want independent counsel, please have them look at it. But that will allow me to continue to represent you. And if it's that kind of situation, if it's something where that there's nothing you can correct, you can disclose, you will disclose it in person or orally, and your writing will be very simple. Dear so-and-so, as we discussed, the time to file your action is now time barred. You may have an action against me. You should consult with another lawyer. I can no longer represent you in this case. Sincerely, Annie Thompson. Mistakes happen. Again, going back to that, sometimes it's not the worst thing in the world because they still have to prove the case within a case. But disclosing calendar errors is part of the ethics of this. And so not making the calendar errors in the first place is obviously the most critical part of this. So we've talked about the benefits of electronic calendaring as far as integration, compliance, and risk reduction, and enhanced accuracy and efficiency. But there's also a cost effectiveness part of this that, depending on the size of your practice, you need to evaluate, because you can have long-term savings on administrative overhead and risk mitigation in the same program that may be a cost savings to you, although while these services are not free and you may think that your small practice doesn't need it, it may be something that long-term is cost-effective for you. So it's also important when you are vetting calendaring software that you adopt calendaring systems that are tailored to your legal practice. And again, the most popular ones that I know of are Clio, MyCase, and Practice Panther. And they offer integrated calendaring features that sync with case management tasks and deadlines. We have automated reminders, deadline calculations, and cloud-based access. That is a lot of protection for you. And that's really what you want, is as much protection as possible. There's also Law Toolbox, and that's a court rule-based calendaring system. And they will specialize in calculating deadlines based on court rules and jurisdiction. And that the benefits of that is they're accurate, jurisdiction-specific deadline tracking. People's practices since 2020 have become geographically more diverse, is what I see. The world got smaller by virtue of integrating electronic technology. I can take a deposition, in Northern California and be a Southern California lawyer. Obviously, you have to worry about unauthorized practice of law outside of jurisdiction, but because the way that we litigate now is different, you may be in different jurisdictions than you used to be. So knowing those local rules and having a court-based calendaring system to give you jurisdiction-specific deadline tracking is another, important consideration to make. And then, lastly, what I will say before I get to my checklist is tools like Outlook, Google Calendar, Apple Calendar, those can all be adapted for easy use too. They're easy integration with email and mobile devices. They require manual input of deadlines. I prefer manual input of deadlines because I'm doing that myself. You don't need the most sophisticated tools, but you need tools, and you need electronic tools, and you need repetition and duplication. And if you're delegating this, you need everybody's buy-on and everybody's consistency in how they're calendaring and color calendaring and features that that are apparent to everybody within your law firm. Okay, I have a question here in my Q&A, and it's hypothetical. Oh, goodness. International entity client in-house counsel is located in a different jurisdiction/country, may not be licensed in forum or state. PMK is scheduling necessarily delegated through in-house counsel. The court has ordered you to produce PMK in 10 days. The scheduling efforts fail and you are at a continued hearing without a date. How do you explain this hypothetical to the judge in compliance with Business and Professions Code 6068E1? This is an extreme hypothetical, ... It is an extreme hypothetical, and I can issue spot a number of things with that. I mean, it raises issues of unauthorized practice of law. So this really isn't a calendaring issue. If you have an international entity client located in a different jurisdiction and you're not licensed to practice in that jurisdiction, you've got some problems. You're ordered to produce the PMK in 10 days, and it's unclear to me, but it sounds like maybe your scheduling efforts with the PMK have failed, and you're at a hearing now with the court, and how much can you disclose about your inability to get your international clients compliance with this. This raises a whole host of issues completely separate and apart from calendaring. So I would just point out, your duties of confidentiality, your duties of candor to the court, You have to zealously protect your client and make sure that you're not revealing any confidential communications or information in that scenario. Um, Again, but show up in the 10 days and see what you can do. So I guess it can apply to calendaring in that regard. But that is an extreme hypothetical and very complex, and I would go through it piece by piece with you on a hotline, but I'm not sure it's right for this audience on this topic right now, but hopefully I've identified what I can for you. And then a question, does my case syncing to Google Calendar meet the redundancy requirement? Do I need an additional service? So that seems to me to be sufficient. My case, syncing to Google Calendar and Google Calendar being presumably in the cloud and on your phone, and on my case, has a redundancy element. I will tell you that I have Google Calendar and One Calendar and Outlook Calendar for like triple redundancy. I don't know that that is the standard of care. I do think there may be a sort of best practices element to, Google's gone down before, but so has Outlook. But I do think that certainly you're meeting an ethical requirement of having redundancy in place, having case management software in place, creating the documents, but it is your duty. Google Calendar is manual entry sometimes. So it's not going to capture all the things you need it to capture, like your client meetings, but it is going to capture all the case information that my case will sync with your system. So that is definitely a fine way of handling it, as long as you're vetting your systems and making sure that you're, consistently updating. Like I'm having an issue right now. One of my calendars is not syncing with the other, so I'm missing appointments. I have backups because I know that it's on the other one, but one of my calendars is not syncing with the other one. That's why you need redundancy. Ironically, that just started happening in the last few days before I do a calendaring seminar, of course. The last thing I'm going to share a screen with you, because this is really going to be, and it's in your materials, and this is going to be kind of, let's just share it. So this is a checklist, and it's in your materials. And this is a checklist for evaluating and implementing electronic calendaring systems, was essentially is, the message I'm leaving you with in this seminar is that electronic calendaring systems are the future, the present, and you need to leave your paper calendars in the past, or they can be part of your redundancy. They just can't be the only thing you have. So this is a very hopefully complete checklist of evaluating and implementing electronic calendaring for California lawyers. And you want to make sure that this is tailored to your practice. So you look at, compliance with California law, court rule integration, customizable workflows, recurring appointments, conflict checking, which is huge, and it's definitely a whole different CLE, but integration, mobile and cloud access, and then, collaboration depending on the size of your firm. Security and compliance, data encryption is, on our cyber side, encryption, which if your data is encrypted and a bad actor accesses it, all they get is gobbledygook. They won't get anything readable. So encrypting data, again, cyber is probably a whole different CLE, but it's something that you need to be aware of for your security and compliance with calendaring, is finding out if somebody does access my system, is my data encrypted in such a way that if I have 20 years of files, that nobody can do anything with them. Again, you need controls as to who can access the calendar data. You don't want, if you have a disgruntled employee who leaves, you want to make sure you can turn that access off immediately. And with respect to, integrity, you want, logging and audit trails. So the integrity of the information is intact. And again, backup and disaster recovery, compliance with the ABA, but most of the lawyer-based things will meet the ethical obligations for client confidentiality, but you need to make sure. Again, integration and compatibility, we talked about syncing with email and calendar apps. Sometimes depending on what your system is, it will read your emails and automatically create calendar entries, which is very nice. And make sure that everything you do is compatible with each other so that you're not running into syncing problems, and that you have the right people and tools to make sure that that doesn't happen. Again, implementation and training. And you'll have this checklist to use, data migration. So if you have existing calendar data, how do you move it into your new system? User training, again, that goes back to the rule about delegations to assistants on calendaring, and then customizing and scaling it to your firm size and needs, which is huge because you don't want a system made for big law if you have a 2-person law firm or a 1-person law firm. And then lastly, and this was the sort of the cost benefit analysis that I talked about before, where I really believe that if you find the right product for the size and needs of your firm, the benefits outweigh the risks of not having a vendor to assist you with respect to your calendaring and your communication needs, as it pertains to your ethical responsibilities to your clients. So I am going to, if there are no more questions, I'm going to conclude this presentation and just share with you, calendaring isn't merely an administrative task. It's a fundamental aspect of legal practice that directly impacts your clients, your compliance with ethical obligations, and the reputation of your practice. By employing an effective electronic calendaring system, you can reduce risks, enhance efficiency, and uphold the highest standards of professional responsibility. Remember that the investment you make in your calendaring system is an investment in your clients, your career, and the integrity of the legal profession. Thank you for your attention today, and I really appreciate you all taking the time to be here. And if there are any questions, I remain available after the program if you would like to contact me about whether it's Lawyers Mutual or any other needs you may have with regard to this presentation. So thank you all for coming today.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.